Our recording. Thank you everyone for joining us today. Second webinar in our series this week. We have two presenters with us to walk us through working with an attorney, with Maria Schmidlkoffer, who I'll let introduce herself here shortly. And then Mark Hudson will walk us through some information about easements. So first off, my name is Andrea Kramer. I'm the Education Program Director for Oregon Agricultural Trust. We are a statewide land trust working to preserve farm ground into perpetuity. One of those ways that we're doing that, making that effort, is through education. So this series this week has been to help start the conversation about, continue the conversation, work through the conversation about succession. So we work with folks in a number of different ways to help that progress with operations throughout the state. So thank you for joining us. And with that, I will turn it over to Maria just for the day. I think we're going to hear from Maria for roughly an hour-ish plus or so. And then we'll take questions after that, but also questions during. So if something comes up, please feel free to ask in the chat, raise your hand. I'm happy to monitor the chat and make sure we get those questions. But then just as a wrap up there at the end of Maria's presentation, we'll do a call for questions there before we hear from Mark. So just to make sure that we kind of accumulate those questions for Maria there. So with that, why don't you take it away for us, Maria? Let me make sure I give you permission to share your screen. Okay, you should be able to do that now.
Okay, great. Just getting my slideshow open here.
Absolutely.
So I want to play from the beginning, and for some reason it looks different than normal. One moment. Well, for some reason, it's not letting me share my slideshow. So
let's see here. I have the PDF version that you sent me. If you'd like me to share it from my side.
Here, let me try one more thing here and then we'll go. Sorry, guys. So my name is Maria Schmidlkoffer, and I'm an attorney with Schwabe, Williamson, and Wyatt, and I work out of our Salem office. And I've been doing farm and ranch succession planning for the last 16 years. It's what I've dedicated my career to. So I really love talking about this stuff. And usually it's pretty easy to go for it here. And so what I'll do is I'll just go ahead and share my screen with the way it's showing it here. And can you guys see the slideshow okay?
It's thinking about it. There it is.
Okay. And
I think could you be able to, let's see here. So you go slideshow. Yeah, from beginning, clear over to the left there.
Yeah, and that's what I was, there it goes. No, it's working just fine. Thank you. So anyways, we have a packed little agenda for this lunch hour, and what we'll be talking about is what is estate planning and succession planning and how they relate to each other, common mistakes related to estate planning and wills and trusts, how to transfer assets, the core documents that are involved in estate and business succession planning, estate tax issues that come up, as well as tax relief for ranchers, gift options, and then business succession, and some real life examples of how people do this kind of planning. And then we'll finish it up with addressing common issues that come up. So, and feel free to just let me know if there's questions, Andrea. and stop
I
me
will. Yeah,
as
I
I
will
go.
monitor the chat.
Yep. And so just to start things off here, I thought I would show you guys a picture that I took at my kitchen table last week. This stuff is real to me. I live on a farm outside of Salem in this little area called Shaw. And it's just, that's why we do what we do, is because there's meaning to the land, and being able to pass it on is just, it's different than a lot of estate planning. It means something different. So what is estate planning? Well, the funny thing is when a lot of times when I work with people, they say, oh, I got my will done, I have my estate plan. And that's one piece of an estate plan. But really, estate planning starts with you as an individual and making sure that you're going to be okay. So you can stay in control of your property as long as possible, a plan for you if you have an emergency. And then sure, it is also giving what you have the way you want, to who you want, when you want, but that's almost secondary to the planning process. We have to start with making sure that you're protected, and then we move into how do we get it to whoever you want it to go to. When we talk about ranch succession planning, it involves two different things. And I really appreciated attending yesterday where we had Christy talk about business succession planning. I have some of those same concepts today that I won't go through in depth since she covered a lot of that yesterday. But a business succession plan is not going to work if your estate plan doesn't match everything that's in your business documents. So you have to combine the two when you're doing a succession plan. You have to have both the business side set up and you have to have the estate side set up, and they have to talk to each other. They have to be able to have the same thing flow together, because if they don't, if they have different things, like your business documents say, give this business entity to this person or buy it out this way, and your estate plan says something totally different, then that's when we get into litigation and it just doesn't work. So making sure that they are both working. So as a little warm up, I like to talk about common mistakes that I see through the lens of celebrities that had these issues. So the first thing is not having a will. As we heard yesterday, 81% of farmers and ranchers have no plan, meaning there's nothing in place for how to give it to the next generation. Only 30% of small businesses in North America will actually transition successfully to the next generation. Those are some crazy numbers. So the first mistake is not having a plan. That's called intestacy. And that means that you don't have any will or trust or anything in place that's going to say where your stuff goes. The famous celebrity that had this was James Dean, and he died without a will, and his estate went to his father, who had abandoned him when he was 3 years old. And it still produces $1 million a year in royalties. So get a plan in place, because otherwise the state writes it for you, and it's probably not what you want to have happen. Even if it's just a basic plan, that's better than nothing. So another common mistake I see is that you think you have a plan in place, but it's unenforceable. So one thing I remember doing when I was in law school, before I was an estate planner, was at the time I had a 1-year-old son. And so we'd go on vacation and write, this is who's going to take care of my son if we die in a fiery plane crash or something, right? You leave this frantic message, so that somehow, some way that'll work. Well, people do that all the time, I find out. And they actually try to do that as their will sometimes too. And guess what? That doesn't work. It's unenforceable. And so what happened to Marilyn Monroe's estate is that her will said, I give this to my acting coach, 75% of my estate, with instructions to give it to charity. Well, the way it was phrased, he didn't have to give it to charity. And guess what? He didn't. He gave it to his new spouse, who she'd never met. And so now that spouse's descendants is actually who inherited Marilyn Monroe's estate. So when you do have a plan, make sure that it's doing what you think it's doing. I see this a lot in blended family situations. If you're in a second marriage and you have a plan that says, here you go, everything to spouse, then when you're both gone, everything to kids. Well, the spouse can change their mind. And so then they accidentally disinherit the kids later on. Or just anytime that you're giving too much discretion to the people you put in charge of your planning. It's a common mistake that we see in this field. Another common mistake is where what I mentioned at the beginning, that the business documents and the state planning documents don't match. And so they're unenforceable last wishes. So a real life example of this is one of my partners had done, I don't think it was actually her estate plan, but she was doing it after the person died. She was administering their estate. And they had a trust, and the trust said that they wanted to hold the farm in trust for the spouse, who was a second spouse, for life, so that she could have rents basically from the farm, at least from their interest in it. And then it would go down to the first, the guy who passed away, his kids after she passed away. Well, the business document said, you don't have to do that. You don't have to allow a spouse, even a spouse in trust, to come in and hold an interest in this farm, this LLC. And the business documents, in fact, said the opposite. They said anytime someone passed away, it triggers a buyout. And the other members, which were the children, could buy out that person's interest who died. And so the kids didn't care for a new spouse, and they just bought her out, which, I don't know, maybe that was the right result ultimately, but it certainly wasn't the intent of the planner or the person who had the plan in place, because the trust was really clear, this is what we want. But the business documents said something different. So the last wishes were unenforceable. I see this a lot also where people write letters, or they put duct tape, on things in their house and say, this goes to Johnny, this goes to Susie, what have you. That doesn't work. I have personal experience with that not working. Also giving oral instructions doesn't work, because there's no way to prove that that's what the person actually said or wanted, and it's not enforceable. Or just trying to change your will or your trust in a way that's not through a legal document. So with Princess Di, she had a letter of wishes to give some things to her godchildren, and her trustees, who are her mother and her sister, had it overturned as unenforceable. They didn't want to give any personal effects to godchildren. And so the court said, yeah, you don't have to. So making sure that whatever you want to have happen actually is going to happen. And then poor tax planning. I see this all day long. I just had a client recently whose parents thought they had a good trust plan for their farm. And when the second of them passed away, it turned out that their estate was just a little bit too big to take advantage of some of the Oregon natural resource credits that you'll hear about. And so they were excluded from taking any of those credits. And that meant that they had to sell one of the farms to pay the taxes. I see this all the time. And so making sure that you've gone to somebody who actually knows how to do the tax planning is really, really important, especially as it relates to ranching and agriculture, because there's different rules that apply to that. And also to update your plan. So sometimes someone will have done a trust like in 1995. Well, the laws were different then. So please take a look at it, have your estate planner take a look at it and make sure that it's addressing both the state and the federal tax laws. State of Oregon implemented an estate tax in 2001. So if you have trusts that are older than that, it doesn't say anything about the Oregon estate tax. And then just making sure that you have the right kind of tax plan, because I'll see tax plans and trusts that just don't make any sense given whatever it is that you own. And so those are just some things that you always want to update every 3 to 5 years, is my rule of thumb. So assuming now that you're getting organized and you're ready to do your planning, what are the things that you need to do in order to meet with an attorney? And we heard some of this from Diane yesterday, and I thought she did a really good job of saying, hey, try to get your ducks in a row as much as possible before you meet with your lawyer, because lawyers are billing by the hour. That's true. But if you if you aren't ready to know everything about your planning and do your succession plan on your own and try to figure that out, I will say that if you can just get a few things in order, then sometimes what people will do is they'll meet with me for maybe like an hour or 2 hours. And I'll say, great, these are the next steps that we need to know in order to start getting a plan in place. So don't be afraid of taking that first step with a lawyer. Sometimes I think it's one of those things that just seems like a big insurmountable thing to have your planning all organized before you come in, that you don't have to have figured it all out. So, but we will need to understand what you own and what that's worth, because that's what the government asks someday when you pass away and you're trying to pass it on. And so you have to have a clear understanding of your business assets and liabilities and how it all works together. So how your operations work. And then usually I'll work with your accountant to make sure I have a full understanding of what, for example, if you have a corporation or an LLC in place, how those are all flowing currently. And then you will have a joint meeting a lot of times with your attorney and your CPA to figure out what are your goals. And then we break it down on how to get there. So with any business succession plan, like I was saying, you have to have your estate plan and your business succession together. And so the first step with estate planning is to decide if you're going to have a will plan or a trust plan. A will is the same thing it's always been, hasn't changed. It is a document that says when I die, I want my stuff to go to X, Y, and Z. The way it gets to X, Y, and Z is by a court process called probate. If anybody on this webinar has dealt with an Oregon probate, I'm sure that I'm preaching to the choir when I say it's not a fun process to go through. There's a lot of hoops you have to jump through in order to get through a probate. It takes about a year. The positives of it is it's cheap to set up a will, and the probate process does cut off any future creditors from many claims. So it doesn't have any planning for during life or for disability. It's merely a document that says when I die, this is where I want my stuff to go. It works, it's legal, people still do wills, it's okay. That's better than not having any plan. Most people that I work with on the ranch and farm succession planning end up doing a revocable living trust. It is a really different concept than a will. It's more like a private contract that you sign with yourself, which is a little counterintuitive, that says that I want to transfer my assets, my business assets, into this thing called a trust. And the trust will hold those and I will manage it as long as I'm alive, and I can change it as long as I'm alive. But when I die, the trust will pour out and go the way I say. So it doesn't go through the court probate when you die. It stays private in your family and with your trustees. And so it doesn't have to, because it doesn't go through court probate, it doesn't take usually a year to go through a trust and administer it and transition everything to the next generation. The negative of a trust is that it's more expensive to set it up than a will. So there's a higher cost to setting it up. I would say that it's a lower cost though someday when you're distributing everything out to your family to deal with it at the end, because the probate's very costly. So so you either need a will or a trust. With a trust, picture you're writing a contract, right? Usually you write a contract with a third party like the bank or something. You're entering into a loan, let's say. With a trust, you're just doing a contract with yourself. So you're creating the trust as the trust maker, and you're in charge of the trust as the trustee. And so it's like this little imaginary bucket that goes around your assets and anything you put into this trust that you continue to manage. And so here's a visual of how that works with your ranch. So in this example, let's say you are married husband and wife, you have a ranch. The ranch has an operating company that's an S corporation, and it has an LLC to hold the land. And right now, those are just in your own name. When you work with an attorney, what we'll be doing is we'll be transferring those interests into this thing called the revocable living trust. You continue to manage it just the same way you always have. You won't notice anything different. But when there's an emergency, the trust kicks in to say, hey, if you can't be the trustee, someone else steps in and manages it all for you for your benefit. If there's a different kind of an emergency, like you pass away, then the trust says, okay, this is where these are all supposed to go, and it's handled privately. So, so that's why folks are doing the trust planning. And when you're doing any type of planning, the key is making sure that how you own things is actually the appropriate way of owning it. So we actually look at ownership. And I feel like attorneys don't always do a great job of this piece because it's kind of the least fun part of all of this, if you can call estate planning fun. That what we're doing is we're saying, okay, you list out all of your assets, everything you own, and then how you own it. So do you have a bank account that's jointly held with your spouse? Do you have a bank account that's just in your own name? What about your ranch interest? Is that just under your own name? Is it under a business that's held in your own name? And then we're trying to transfer everything when we're doing a lot of the planning from the first two categories here to the last two categories. So instead of owning something just personally in your own name, when you die, that goes through your will, which goes through court probate before it can get to your family. We're trying to get it out of your own name into either a living trust or to put a beneficiary on that. So you can put beneficiaries on accounts, for example. If you own it jointly, then we're trying to get it out of joint ownership, because that ends up just going back to category one when one of you passes away. And then over to, again, named beneficiary or living trust. The other issue with joint ownership, I have a big pet peeve with joint ownership. A lot of people will do what I call self-help estate planning and add their kids' names onto accounts. They'll even add their names onto deeds. I've seen all kinds of things that people just add their kids' names on there to avoid probate. That causes all kinds of issues. First of all, it's counted as a gift when you do that, and it's likely reportable. It also destroys any chance that the child could have a step up in whatever the basis of the asset is. So if it was that you added their name onto a farm, for example, that gift was made and now they've basically inherited it early unintentionally. And also, if the intent is for it to be split among more than one child and you've just added their name on for convenience, guess what? When you pass away and it goes to that person, they don't have to share with their siblings. And a lot of times they don't. And so please don't do the adding children's names onto things to avoid court or for whatever reason, because it just causes all kinds of liability issues and unintentional consequences. So really, like I was saying, we're trying to get things over here into the beneficiary and the trust category to make it easier to transition someday. The core documents that you all should have in place, at least 4 of these 5 documents, and those are durable power of attorney, which I'm sure many of you have dealt with powers of attorney before. I like to do a very broad general one. It's about a 25-page document that lists all kinds of things that you want someone to have authority over to sign on your behalf in the event you have an emergency. So a common one that I've seen is, let's say you're selling a car and you don't want to. If you have a power of attorney, your power of attorney can actually sell it on your behalf. Or if you had, let's say you were disabled and you couldn't sign anymore, they can sign your tax returns on your behalf. They can do all kinds of things on your behalf in order to make sure that your assets are still being used for your benefit and are able to move forward without a court process. If we don't have something like that in place, a lot of times I get hired to go to court and get what's called a conservatorship in place for the person. So the person, like right now I have one going, the person is in the hospital, she had a stroke, she's not recovering well. And so the hospital can't even like release her or anything without a legal document that says this person has authority to, you know, to make my decisions, to put me in a different place or to pay my bills or anything. And so the hospital actually required the family members to hire somebody like me to go to court and get the conservatorship, which is power over the person's money, and a guardianship, which is power over the person. And that's all court monitored. And that's what you have to do if you don't have some of these documents in place and there's an emergency like that. It's very expensive too. So the power of attorney is a super easy document to get in place. It's inexpensive, and it can handle things like dealing with an emergency situation, whatever it might be. And it's good as long as you're alive. So along with that goes the medical directive and HIPAA waivers, and that's appointing a medical person to make decisions for you if you can't speak for yourself. And then, of course, a will you need in order to transition your assets after you pass away, or the trust if you do the trust-based plan. So I always say, surprise people, I think, when I say anybody who has adult children, make sure that anybody over the age of 18 at least has the power of attorney and the medical directive and the will, because then you can still deal with things if they have an emergency. So if they're going off to college or whatever, make sure those are in place before they leave, because then it's just one less thing that will cause problems if there is an emergency. So with the trust, there's different phases that the trust has for the planning. And so we talked about during life, you're in charge of it. And that if you had an emergency, there's a disability trustee. And so they can step in and manage your ranch on your behalf. You need instructions about how they should do that. If there's special things going on that they would need to know about. So one thing that, and I think Diana mentioned this yesterday, is making sure that you have some kind of a procedures manual, or this is who you call if there's an emergency, somebody who's in the know besides you on the daily way that things are working. So that way, when there is an emergency and the disability trustee has to step in and take over things, it can continue on without causing huge issues, or even worse, forcing a sale or something like that, because it's not being managed appropriately. The other thing I always say about disability is you should also have instructions in there about if there's things that are funny that you might need to make sure someone knows is okay. So a common thing I see with ranches is maybe you have a relative living in a house on one of the properties and they're not paying rent, but you're allowing it because they're going to school or they're helping out or things like that. If somebody is living in your house or on a property and there isn't a lease in place or an agreement in place, and you have an emergency, you became disabled, the trustee or whoever's in charge of your assets would have the duty to basically kick them out, unless there's an instruction saying, no, that's okay. That's my nephew. I'm trying to help him out while he's, getting his life back in order or what have you. So you need instructions about kind of just quirky things that might be going on too, that would be relevant to your estate and your planning. Then the next phase of the trust is when, if you're a married couple, if one of you dies, then there's different trusts that will pop up in the event of death. And that's when it's really important to have those buy-sell provisions in your operating agreement or just buy-sell agreement that match whatever the trust is saying or the will is saying for how things should happen. Because if those don't, then that's where problems can arise. And then after you're both gone, the trust pours out to whoever you say, however you say. So you choose how your family inherits. So with the planning, a lot of times when I'm meeting with people, we're talking about estate taxes. They're still important. We still have both state and federal estate taxes. Once your estate hits 1 million in assets, it starts out at a 10% tax. And then that slowly ratchets up to a 16% tax for Oregon on a $9.5 million estate. So it's very easy to hit the $1 million. It's been stuck at $1 million mark since 2001 when they implemented this tax. And so there hasn't been any adjustment for inflation or anything else. And so think about it. If you have a home, if you have a ranch, if you have a retirement account, any of these things, the fair market value when you pass away is what's looked at to determine if a tax is owing. And so that sneaks up and hits a lot of people who aren't expecting it. Federally, it changes every single year. Right now, it's the best it's ever been as far as the lowest taxes. In 2023, you can have 12.92 million in assets before there's a federal estate tax. That there's a 40% tax once you hit that on anything above that. And if that was going to be a permanent thing, most people don't even need to talk about federal estate tax. Some actually ranches still do, because it's easy to, as your ranch gets bigger, the value of that land just keeps going up, even though you're not noticing it because you're not seeing more cash in the door. It's just that your land's appreciating in value. And so a lot of my clients in Eastern Oregon are actually hitting these numbers because of just appreciation of the land over time. And it seems like keep getting bigger over time too, as neighbors sell and things like that. So the problem with this tax is that it changes frequently. It's changed every year. I've been doing this for the past 16 years. It's been a different number. And so we can't rely on someday when I die, I'm going to have a $12 million free coupon to give to my kids, my estate, and not pay a federal estate tax. It's supposed to go down to a $5 million exemption in 2026. That's adjusted for inflation. So it'd probably be around $6.5 million exemption with a 40% tax on anything over that. That hits a lot more people, right, that have ranches, because now, like I said, the land values just keep going up, and we don't know where it might go in the future. It seems like every time there's a change in administration, they look at monkeying around with the estate tax laws. It's not one that a lot of people protest, because dealing with the states, right? There's nobody to argue there. And so it's a way for Congress, I think, a little bit maybe cynically, to balance their budget, to say, oh yeah, well, if we lower this estate tax to all estates over 2 million, then we'll get this much more money to, buy other things. And so I worry about that for farm and ranch clients, because we just don't have a guarantee of where that will go in the future. So a lot of my ranch clients that are doing this kind of planning, if you have a legacy property that's supposed to stay in your family forever and ever and ever, we're really looking at gifting. And we're trying to capture some of these big coupons when we have them and lock them in that way. And I'll talk a lot about gifting in a little bit, but just know that while it looks pretty good today, you need a plan that is flexible with whatever it might be in the future, because it goes up and down every year. Income taxes is a big reason why a lot of people don't gift. Not that anybody who gifts has to pay income taxes necessarily. It's just that if you've inherited, for example, your ranch, and you inherited it in 1970, let's say, and the value of that in 1970 was $100,000. Well, now the value today is probably going to be something like 5 million, right? And so then if you give that away to your kids, let's say, while you're living, the value that they're getting it at is 5 million. That's what we report the gift as, right? If they decided that ranching's not for them, they want to sell it and move to, I don't know, where do people want to move these days? Maui, let's say. Then they would pay capital gains income taxes on the difference between what you inherited it for, the 100,000, and what they sold it for, the 5 million. Now, if your goal is for them to hold it onto it and give it to their kids, maybe you don't care, because in some ways it serves them right, for not following your wishes. But if you want them to have the most flexibility to do what they want with it, then this is a big consideration, because if instead you hold on to it and give it to them at your death, it steps up to the value of 5 million. Then if they turn around and sell it, they're not paying those income taxes in the same way that they would if you had gifted it to them. So whenever we're doing the planning, there's a lot of considerations of what's most important here. What are the long-term goals? That's why it is really important to go to somebody like Diana's class and kind of figure out where you're at with a gut check. Now, sometimes I'll work with people and they'll just say, oh, the kids are going to do what the kids are going to do. I have that client right now, in fact, 2 kids that don't have any interest in the farm. And it's sad, because it's a beautiful place, but they've never come back to it. And so if it's going to be sold, we need to go in with that with eyes wide open, because the planning will look different than if it's planned to be kept forever. So income tax issues are still a big deal on this chart. This is an old chart, but I just love it because it's so great to illustrate, you know, where we live. You see the light colored green on this chart is the lower tax places, and then for income taxes, and the dark colored green is the higher tax. And you can see Oregon is, the last time I checked, the third highest when you combine income tax rates in the country, behind California and New York, and maybe New Jersey. We're right around New Jersey's level, I think. So it's, if you're thinking about kids' future selling property and capital gains, that's where we get into these issues. So a sample estate plan would look like something like this. And when I say sample, I truly mean that. This is the generic version, but a lot of times, most times I would say it doesn't end up looking anything like this. This is just kind of like, if you're trying to visualize, how would this all flow through? Let's say Tom and Susie Jones have a ranch that's worth $6 million. And they stuck that ranch, was held in an LLC or a couple of LLCs, let's say, they put that under their living trust. Someday Tom passed away. And as we said, well, Oregon has $1 million estate tax, and anything over $1 million, or $1 million exemption, anything over $1 million, there's a tax. And so they said, well, gee, 6 million is more than 1 million. So how do we avoid that? Well, one thing you can do is you can preserve your million when you pass away, and then the spouse still has her million too. So in this case, Tom could preserve his $1 million coupon by putting it $1 million of assets down into this thing called the family trust. Susie gets to use this trust, and she could even be the trustee of it her whole life. And then his other 2 million, so they each had 3, right? $6 million estate. Oregon is considered a separate property state, meaning you own 50-50, unless you say otherwise, as a married couple. The other 2 million goes into this thing called a marital trust, which is protected from federal estate taxes, but subject to Oregon someday. And then Susie's other half just goes in the survivor's trust. These two Susie can use, but ultimately they must go down to the kids. These little magic wands indicate that you could give Susie the power to change who it goes to. So if Anna turns out to be ungrateful brat, then you could give it all to Tom. Or you have flexibility built in depending on what the situation is with these trusts. And then Susie still has the other half that she can do whatever she wants with it. So this is a traditional tax plan where you own it all together for a married couple. It splits in half when one of you dies. And then because Oregon and the federal government have different tax rates, there ends up being more than one trust for the deceased spouse's half. Ultimately, then what happens is the family trust pays out someday when Susie dies, along with the survivor's trust and the marital trust. There's no estate tax of any kind on this one. There may be Oregon on the marital trust, and then Susie has her $1 million coupon that's tax-free for Oregon, and the rest still is subject to tax. And so you get more to the kids if you split it apart like this when one of you dies, if you have a taxable estate. The good news is both the state and the federal government have some estate tax relief for farms and ranches. And I'm not going to get into the federal requirements today, but I am going to talk a lot about Oregon, since it probably hits pretty much everybody on this call. If you have a ranch that's worth $1 million or more, then your planner should be looking at this option. It's called the Oregon Natural Resource Credit. We've had it since 2008. So yes, the legislature did something that helped Oregon farmers, and it's still on the books. And most of my clients are planning to try to take advantage of this option. So the first requirement for it is the value of your natural resources property, which includes ranches, has to be at least half of your estate. If it's less than half of your estate, then you cannot take advantage of this. So if you had an estate that was worth 8 million and 6 million of that was a ranch property, then that would fit, because you'd have to have at least 4 million of the 8 million in ranch, and you had 6. So the next requirement on this is that your estate has to be valued under 15 million when you die. And so like if I'm working with spouses, I can get it so it's 15 million each, right? Through splitting apart the trust and things like that. And so in that example that I gave you earlier, the one that was disqualified from this tax, it was because the estate came in just above 15 million because the farms had appreciated over time and the person just didn't realize how valuable they were. And so you have to keep it under 15 million in value to get this. At least half of it's in ranch and farm, right? And then you can take it on the first 7.5 million of property that's involved in ranching farm, the natural resource property. Then the kicker here is that you or a family member needs to have continued operating it at least 5 years before your death, and then 5 years after your death. So if you have a family that may not want to continue ranching indefinitely, it's worth having a conversation with them to say, well, would you do it for at least 5 years? Because then you can take advantage of this credit, which is a huge reduction in estate taxes if you can get it, depending on your circumstances and how valuable your farm or ranch is in comparison to the rest of your estate. So it also includes timberland. It can include the home on your ranch, and it even can be your operating account. So that surprises some people. If you keep money in your operating account, it can be up to 15% of the total value of the credit, or $1 million, whatever's less. So, and you can have your property in an LLC or a trust and still qualify for this. And as long as the family members are materially participating in the ranching after you're gone for those 5 years, then they'll continue to qualify. So a lot of times I'll have someone who's not necessarily a farmer who inherits or a rancher, but they live on the property and they provide security and they fix the fences or do like what I was doing last weekend and burning the brush piles and things, you know, the cleanup, that kind of stuff. That counts as material participation. You don't have to actually be out running, you know, the livestock or doing those things. You just have to be somehow participating in it. So if they are, let's say they only make it 3 years and then they say, I don't want to do this anymore, you get a 20% discount on the tax every year. So 20, 40, 60% discount after 3 years of continuing it on after you're gone. So it's a worthwhile thing to talk to your family about and see if you can qualify for it. And when we're doing the planning, a lot of times we're talking about, will that fit, you know, the natural resource credit? Does it make more sense to gift with those, you know, capital gains if your kids ever sell? And we're just trying to navigate between these two different kinds of taxes and figuring out which one fits the best for your succession situation. So with gifting, there's, you know, all different ways you can gift. The most common one that I have seen is that people think, well, I can give $10,000 a year to whoever I want. That $10,000 has actually adjusted up to $17,000 a year now. And you don't have to report it to anybody. You can give up to $17,000 a year to whoever you want. So if you are an individual that and have one child, for example, give $17,000 every year to Johnny. If you're a married couple, you could each give $17,000 a year to Johnny. So that'd be $34,000. And again, no reporting, no tax consequences to this. If you're a married couple and Johnny's a married person as well, then you could actually be getting $68,000 out every year just through this. It's called the annual gift exemption or exclusion. And so that's a common thing that people do. But what a lot of people don't realize is that there's another rule that says you also have this lifetime gift exemption on top of that. And it's tied to that estate tax coupon federally. So remember I was saying there's a $12.92 million federal exemption for when you die. Right now you can pass that much on to your heirs without paying a federal estate tax. Well, what a lot of people don't realize is you can use that during life. You can use it as a lifetime gift instead of an estate exemption. You can use it to gift $12.92 million without paying a gift tax. It changes dollar for dollar how much you can pass at death, estate tax-free federally. Oregon doesn't care. Oregon has no gift tax. They don't care if you gifted 20 million during life. They don't look at that. It's just the feds that look at it. And right now, federally, you can gift during life or at death, the 12.92 million. So there's huge advantages to looking at gifting as an option to the succession planning, and getting some of that in place while you're alive and able to do it is a good option for many people. So an example of this, because Oregon has no gift tax, and let's say there was an estate with $2.5 million, said Mary dies with $2.5 million, her estate would owe $152,000 normally of Oregon estate tax. If instead she gave away $1.5 million right before she passed away, then there's no Oregon estate tax. And $2.5 million, giving away the 1.5, well, that's less than the $12 million exemption federally, so the feds don't care either. You have to report a federal gift, but there's no taxes owing. And so that's why gifting is so popular right now, is because it's a good way to get assets out of your estate. I'm not going to get too in depth on these things here, because I know that yesterday, Christy did a great job of talking about like, how does the business succession work for a lot of folks. But what I'm mostly working with on this flow chart is generation 2. So these are the people in their like 60s, 70s that are still working hard, running the farm or the ranch operations, but they're looking to get out of that and retire. And they might still be taking care of mom or dad also on the ranch. And so the tricky part of this all is figuring out, how do we bring in the next generation and create enough income generation for generation 2 to be able to retire. And so that's where you have to look at making sure that we look at any risks related to the business, that the business will keep functioning as we transition it, and it addresses whatever those family dynamics are. Before we start giving away business interests and things like that, we have to figure out exactly how that'll work within the family. So, and again, I don't want to repeat things that were covered yesterday, but it really is, as part of the estate planning, we're talking about all of these things. We're talking about what are your goals for the next generation? How is the ranch working? How is everything operating? How profitable is it? And then a lot of times we'll need to get a lot of the corporate documents in place at the same time that we're doing the estate plan, because I think one of the slides yesterday said something like 84% of businesses are just owned individually as sole proprietorships. And usually when we're transitioning the business to the next generation, that's not a great form or way of owning it to do so. So we are trying to transition it into an LLC that's more easily transferred to the next generation. And so as Christy talked about yesterday, we form the LLC sometimes just for the operations, so that then there's a business operation that can easily be passed. So if one child is the rancher and you want to be able to give that operations to that child, you have it under the LLC, it's easier to transfer it. A lot of times it also provides great asset protection for you personally, because the liability is in the operations, where somebody could get hurt on the job. And so, or you get sued for, having something wrong with whatever it is, the meat or the dairy, the milk, whatever. And so the operating entity serves that dual purpose of being able to transfer it easily to whoever's supposed to be the successor, the next person in line to manage it, and to provide the liability protection, so that if you get sued, you're just getting sued under the operations and not for your land and your bank accounts and your personal home and everything else. And so then once you have the operations in a limited liability company or another entity, like a lot of times I'll see S Corps or even C Corps for operations, it's okay. There's all different ways you can set these up, but LLCs are the most popular, I would say, these days. And then you become employees, right, with Generation 3 and Generation 2, which also starts making that structure for being able to transfer it, because now there's a real, they're getting a real wage. And so there's less of a need to maybe get some of the profits from other things. So how you set that up is super important. There's one family I'm working with right now where Generation 3 is coming on. They had a rule that said you had to go off and work at a different farm for 3 years, and then you could come back. And once you've completed 5 years on the original the family farm, then you get to become an owner. And so during those 5 years, they're just salaried employees. But the nice thing about doing it something like that is, as we're talking about the succession planning, because there's 4 parent owners, and then there's 4 next generation owners that'll be stepping in and taking over some of the ownership and things. The Generation 3 is not chomping at the bit as much as maybe you would think, because they've been on a salary for 5 years. So they're able to support their families, and the farm has taken that all into account with its profitability and everything else. And so then it just makes it easier for them to set it up in a way that's can be transferred. Usually the land ends up in an LLC or multiple LLCs as well. And again, that's because it's easier to transition the land from an LLC than just doing deeds. So like, I'll never forget one of my first years of practice. I'd worked with this farm out in Washington County, and they thought they were doing the annual exclusion gifts every year by gifting a little tiny piece of the land to several people in the next generation. And so at that time it was the $10,000. And so they would get a value from their accountant of, this would be, 1/2 of 1% of this land is worth $10,000. And then they would do a deed for that. And this person did this for like 20 years to multiple people. And so I think there was easily 80 to 100 deeds by the time they were done. And of course, I came in and I was trying to help. The person had passed away. I was trying to help figure out what was in the estate still, because what the CPA showed and what the deeds showed were 2 different things. And they actually didn't even really know what they had left. And I just think, and thinking about it now, I just can't even imagine all the costs associated with all of those deeds and all of that gifting, and trying to transition, the land in that way to avoid estate taxes someday. If you have an LLC and the LLC holds your land, then you can just say, I'm giving 1% of this LLC interest every year. You never have to do another deed, for example. And then the LLC also has rules about how it's run. It has an operating agreement that we do that says, hey, if you own 1%, you really don't have a whole lot of rights to do anything, because it takes majority ownership to do these things. And so there's just a lot of benefits to setting up LLCs, not just for the operations, but also for the land. And they're usually separate LLCs to cut off the liability issues. And also because a lot of the plans that we do, the operations might be going to the rancher and the family, but the land might be going to more than one person. And then there's just really good leases between the operations and the land, so that some of the other kids are getting rents from the operator. And I can talk about, how to set that up a little bit more here in a minute. So, and this, I'm trying to skip over things that maybe we were talked about yesterday, but let's see here. So Generation 3 oftentimes will own their own LLC, and they often will either have that as a gift, or it's a piece of land that they're gifted, or they go buy a piece of land and they have their own LLC. I think it's wonderful when people do that with their next generation family members, because it gives them a little bit of skin in the game, and they, I think it brings a different sense of ownership to the 20-year-old or the 30-year-old who's really coming into this, because when they see that their own business what the bottom dollar is at the end of the year, or if they have to pay taxes, if they're, all of those things. It just brings it home in a different way than you can when you're just gifted something or you just inherit something. So I love the plans that they decide to have some kind of a little LLC or a piece of land that goes to the next generation. It's almost like a little test balloon to see, okay, how's this going to work with this, and how's that going to be handled? And then whatever you do, you really, really, I can't overemphasize the necessity for long-term leases, because if you want ultimately your ranch to be run by a certain family member and that person's going to be receiving the operations, in order for them to be able to continue to work it and operate it, they need the land. They need to know that the land will be there for them to use. And so the way to do that is to have a long-term lease, like a 20-year lease or something like this, that says, hey, if the other child who got some of the land in an LLC wants out, they have to offer it to that operator to buy it. So the lease serves two functions. One, it provides rental income for the non-ranch person if they're getting some land. But two, if they want out, it guarantees that the rancher can buy that piece of land and it can set the price for that. And so, so it's really important. A lot of times I'll see the LLCs all set up or the S Corps, and then there's just not really leases in place, or there's not clear buy-sell provisions in the leases and things like that. So that's something that you should always be looking at. And then making sure that whatever you decide to set up, that it all goes together, it all matches. So if there's buyout provisions, that they're all the same between the different entities, the way they should be. So here's some examples that you might consider if you're thinking about ranch succession. And these are all things that I've done with clients that are commonly done. So I wouldn't be recreating the wheel. The classic example is that whole, if you guys have gone to any of these talks before, a lot of times people talk about fair and equitable are two different things. So if your number one priority is to just make sure that the ranch survives and it's going to stay in the family, the classic way of doing that is you give it to the person who's going to continue it, the ranch. And so that means that the non-ranch assets go to the non-ranch successors. So the kids that don't have anything to do with the ranch anymore. That's not going to be an equal distribution in the trust, right? Because the ranch typically is far and above the most valuable asset. And so sometimes what people will do, they want to do this plan because they don't want their brother, their sister to have to pay rent to another sibling or just deal with businesses and things like that. They just want to keep it simple. They might buy life insurance or something to provide some money for inheritance to the non-ranch children that aren't going to be getting as much. It's not going to equalize anything, but a lot of times people say, well, it's a fair plan because the ranch child's been here for the last 30 years. They've been helping me. It's successful because they've been helping so much. They've even grown it with their own sweat equity. And so it's the right plan for our family. When you do a plan like that, where it's not exactly equal, I highly recommend that you write a letter explaining why you did what you did, just for the other kids to understand why it went the way it did. I find that when children hear it from their parent, then they are much more respectful of it than when they just get a cold hard legal document that says, okay, of course, George got the ranch because he was always dad's favorite. That's not a place that people want their kids to be typically. And so just, if you don't want to talk to them about it, which a lot of people don't, because it's kind of taboo, I think, in American culture, or to talk about death and dying, but it's also just awkward with your children, then writing a letter can go a long ways to explaining, what you were thinking, that it's not that you loved one child more than the others. It's just that you had this beautiful legacy land that you wanted to continue, and that was super important to you, and it didn't have anything to do with the value or the money of it. And I think a lot of people understand that because they've heard from mom and dad their whole lives how important it is to the family to continue that, especially if it's been in the family a long time. And so then another classic example of a plan would you give the operations to the rancher, but the land to all the children with those strict long-term lease between the operations and the land. So that was the example I was showing you on that previous slide of the other kids could own an LLC that holds some of the land, but they are basically stuck with this lease so that it can continue to be leased by the operator, the rancher that inherits the operation side of it. The good side of that is then the kids feel like, well, I'm getting some income still. The bad side of that, as you can imagine, is it can cause tensions in families where they don't get along well. And I think one other good thing though about it is that if ultimately the rancher decides to just cut and sell and leave, then they can sell and they would still be getting part of that. So I think it's a plan that can work in a lot of families. It just depends on what your goals are. A common one that I've seen also, and I kind of like this one actually, is where the operations go to the rancher, and then you might have a land parcel that goes to the non-farm children in an LLC, but then the ranch child gets like the home place or gets the main parcel that's really, really important to continuing the operations, and they get that in an LLC. So they still have to deal with their siblings, through an LLC that they rent the land on, but they've gotten like the most key piece so that they know that they can continue on even if it goes south with their family, or they have to buy them out, or they have to go lease land somewhere else. And so I think that plan can actually work really well. I've liked that plan, and you can really limit what the non-ranch children can do with their LLC that they inherit, down to the point where all they can do is receive rents and they can't complain about it. So there's all kinds of ways to control that if you want to do a plan like that. Another common thing I've seen is people will just put all of their land into a trust that goes for generations. And then that trust is it's the ranch trust, and it holds the ranch, and it's not owned by any one person, but it is operated usually by a family member. And it just continues on in that way. Ultimately, the trust will have to pay out in about 100 years or so, but it lasts a long time if you want it to go down to your descendants and just stay in the family. A new thing that Oregon has is called the stewardship trusts. These you can actually keep going forever. So you can have the land in a stewardship trust forever. The family members, the trust holds the land, not the family members. But the trust can pay out profits to all of your future descendants, and the purpose of the trust can be just to continue the ranch. So there's lots of different ways to set up a succession plan, and it's just really what works for your family, and so it's a very customized plan. If you're thinking, if you heard the part about gifting, you're thinking, wow, how would that work? Just a few things to point out about the gifting is it's really trying to figure out what should be gifted is important. I already spoke to you about that LLC interests are easier than deeds, right? So the other thing to think about gifting is you don't have to just gift directly to a kid. You can gift into a trust for the benefit of a child. You can actually gift between spouses in special kinds of trusts that are out of your estate. And then the stewardship trust can be gifted to, and those are out of your estate too. If you are gifting, this is something that I've just started including in a presentation like this, because I find that people just don't realize that there's certain things that have to be done when you make a gift of a piece of real estate. Number one, it needs to be appraised, okay? Because otherwise you don't really know the value of what you're gifting, and you can't make a completed gift if you don't really know what it was worth, because that has to be reported on a gift tax return if it's worth more than $17,000, and the gift tax return requires an appraisal. If it's less than $17,000, I still like it when people report gifts of the ranch on a gift tax return, because then it starts that statute of limitations running for the federal government to try to argue with it. And if they don't, and that statute runs over a few years, then that gift, we know that's not going to come back into your state and it's done. And so, because there's been some crazy court cases where people thought they gave away the farm, but then the federal government said, nope, you didn't do it right. So it's coming back into your estate. So you don't want something like that to happen. The other good thing about an appraisal is you can get discounts if you're just giving away a minority interest for lack of marketability, because if you're giving away a minority interest and it can't be sold, can't be marketed to third parties. And since it's a minority interest, whoever you're giving it to can't control the business, the minority interest. So there's a lower value than fair market value for those gifts. You also need to make sure that when you are doing gifts, to please update your corporate documents to reflect the new membership interests or the new shareholders. Update your minutes accordingly, reporting the gift. Maybe do a new shareholder agreement if you have a corporation, or new operating agreement if it's a LLC. And then usually in the gifting document that I put together saying we gifted this amount, I'll say, we think it was valued this because we got an appraisal and that's what they said. But if the IRS disagrees, then it'll be valued at whatever the IRS says. So that way it's still a completed gift, even if the IRS reassessed it down the road. So then I think I have about 5 more minutes here. And then Mark is going to take over. But I heard a lot yesterday too about that family dynamics is a key component to succession planning. I really can't emphasize that. So plans that haven't really thought through a lot of the issues end up causing the family to be torn apart like nothing else, especially when it's involving a farm or ranch property that just has this inherent value to the family. And they don't recover from that. Families don't recover when they start fighting over the inheritance. So having a proper estate plan that's organized and clear is really key to making sure that the family can still stay together. That being said, if your family doesn't get along now, don't do a plan that says, well, they'll get along eventually after I'm gone, and just assume that they will, because I'm here to tell you that they will not. That usually inheritance causes even more strain on the family relationships. And so don't assume that everything will just be solved someday when they get inheritance and they'll all get along better then. Because usually the tensions rise and it can get even worse. I used to do litigation for farms and ranches that the family was fighting over them, and people just get irrational about inheritance, and it all comes back to those family dynamics and the family relationships. One tip I would give you about that is, if there's already some resentment between the children, don't put one in charge as your trustee over the others, because that'll likely increase those issues. Consider a neutral third party as a trustee instead. And if your child can't balance a budget and spends all their money, please let us know, because we can't help you do a plan that will protect them if we don't know if they have issues with money, or if they have a gambling addiction, or they're in a bad marriage that could result in a divorce. There's all ways that we can protect your ranch from these things, but we have to know that it's an issue in order to address it. So common triggers. Secrecy is another issue I find with estate planning and succession planning, where if nobody knows what the plan is and then it's just a surprise someday when you pass away, that a lot of times in itself causes issues, because there can be all kinds of unsaid expectations that have never been flushed out. So I'm a fan of just ripping off the Band-Aid and letting people know this is the plan. If you're not able to do that, again, like at least writing a letter that explains what the plan was for and why can help with those things, because otherwise it can definitely cause issues in families not to know, or if just one person knows the plan and not the rest of the family, that usually doesn't go well. Make sure that you've addressed disability in your documents, because most of us go through a period of disability. Fortunately, we don't just, go to sleep and pass away like we all, I think, would hope to. There's a period of disability. And in order for your ranch to survive that, you need to make sure that there's documents in place that address that issue, both financially and medically. Also, when you're setting up your planning, please be specific. One of my favorite clients that I've worked with for a long time now had this provision in his parents' trust. It actually said, give my farm to my boys. Well, the problem is that there was one farm when they set up the plan, but then by the time the plan was being implemented, there was 3 farms. And so the boys thought my farm meant all the farms, right? And the girls said, no, they just meant the one farm that you had when you set up the plan, because the girls, of course, wanted to have a portion of the other 2 farms. So say what you mean and mean what you say when you're doing this planning. Describe the real estate that you're actually putting in a trust or putting in an LLC, and what's supposed to go where. You could probably guess some of the problems with some of these other language, like my son's wife, right? Which wife? If they had a different wife at the time the plan was done than the wife when the person passed away, what was the meaning there? I don't know, because it wasn't named. And then just make sure you're updating both the business and the estate plan regularly. Anytime you update one, you need to look at the other. So if you have a planner that only does one thing or the other thing, like the business attorney or just an estate attorney, they need to be talking to each other and communicating and making sure that it works together, because otherwise it doesn't. Okay. And then if you are trying to pick trustees and you think that a family member or friend could be the right choice, my advice is to make sure that you kind of follow these guidelines, that the person's extremely trustworthy and organized. And then my favorite one is that they are not a procrastinator. Okay. Procrastinators are very difficult to work with when we're dealing with planning and succession planning, as far as making sure that the ranch is still running fine and the estate's getting settled the way it's supposed to, or the trust is getting administered the way it's supposed to. And then you really want, if you're picking a family member, someone who's a good communicator. You don't want the person who just knows best and is going to do what's best in their mind without really telling the others, because that breeds confusion and suspicion in families, even if they are doing what's best. You just need someone who's going to put it out there and communicate well. 3 is always too many. So don't have all 3 children be the trustees, please. And then we talked a little bit about just making sure that everything flows together and works together and they all match up. And then one other key tip here is that you have named backups to your helpers on everything. So, and Robin Williams is the picture because he had a trust in place when he passed away, and he'd named his business manager as his trustee, but the business manager passed away right after him. And so then there was no trustee named, and his trust got brought into court because they had to figure out who should be the trustee. So if he had named a backup business manager, it never would have gone through any court process. Same thing with beneficiaries. God forbid, somebody passes away that you think is going to be inheriting everything. That's a time when you would definitely update your planning anyways, but when you're initially doing your first plan, you still would want to have a backup if that was the case. If it's going down to grandkids, does it need to have trust for the grandkids because they're minors? Does it need a special kind of trust because that one of them is autistic or disabled in some way and they can't receive funds? It'll cause issues. Those are all things that should be processed and thought through as you're setting up your plan. Blended families, that's a whole separate area of planning that if you are a blended family, just know that that needs to be discussed and planned for. And then making sure that when you are setting up the plans for your children, that you've thought about what their issues might be and that the plan will provide for that. Please do not do plans if you can avoid it that step out at certain ages. Like give everything at 21 or give a third at 21 and half at 25 and the rest at 30, because we don't know what your children might be going through at any given age. I once was hired by a 50-year-old man who was just turning 50, and he was trying to figure out how to turn his mom's trust off because he knew that his wife was waiting to divorce him for the trust to pay out and the money to come into their, bank account so that it could be divided in the divorce. So the step out is, in my opinion, not the best way to plan for kids, even if they're super responsible and, good at what they do. They might be going through something that needs a different kind of a plan. So lifetime trusts are very popular and something to consider. And then just know that with ranch planning, it is a unique area of the law, and you really do need a qualified professional team that's going to know the ins and outs and be able to help you through that process. So an effective plan makes sure that you are able to transition what you have to who you want, the way you want, when you want. It's thought out and works with all the goals of the different generations. It deals with the risks of incapacity or disability and has planned for healthcare decisions as well as financial decisions in that case. It provides for your spouse in a way that makes sense, and it promotes family harmony instead of family tensions. You've planned for your kids in a way that protects them and empowers them, however you want to do that. And then it minimizes taxes so that you can pass on the ranch to the next generation. So in order to start going off and doing this, the next step is to meet with an attorney that works in this area, go through your assets and think about who would do what, if you when you become disabled or when you pass away, and how should everything be distributed. Make sure that you have a business plan that matches up to it. So that's it. Thank you.
Thanks, Maria. That was wonderful. We did have one question that I didn't want to interrupt you for, so I thought I just held it. What do you mean when you said the trust would eventually have to pay out?
So usually trusts, it lasts for a person's life. And then when they die, they go somewhere, right? They pay out to the children, or they pay out to grandkids, or they go to charity. But some trusts don't. So some trusts might go multiple generations. And so those are called generational plans. And in Oregon, we have this thing called the rule against perpetuities that says, well, you can go basically to your children, your grandchildren, your great-grandchildren, but eventually that trust needs to end because Oregon wants to have another bite at its apple to pay the taxes. Because in these generational plans, people hire people like me to set them up so that they're not subject to estate taxes at each generation. They get to skip a few generations before they hit the taxes again. But there are some trusts that can be perpetual, even here in Oregon. So there's different ways you can set those up. And a lot of times people are interested in that, especially with their ranches and farms, because they consider them, to be the legacy that they want to continue forever. And so those kinds of plans are really popular.
Perfect. Thank you. If that doesn't answer your question in the chat, just let us know. I had a question for you, sure, Maria. So I know that you are in Salem, like you said, but is this, with so much being conducted over what we're doing today, is if someone is not in the area in which you are located, would they still be able to reach out to you and hire you or seek advice with what they've got going on?
Yes. So this is such a specialized area of the law. I work with people all over the Northwest to do this kind of planning. I would say maybe half of my clients are kind of on the west side and the rest are, all over. And so some people I've never even met in person. We're able to do it all through Zoom. Other times, like I have a family cabin in outside of Baker City, Oregon. So I travel east, as Mark knows, once a year. And sometimes I'll take advantage of that and meet with clients while I'm over there too in person, which is always fun. But yeah, so we work remotely all the time. And, that's been one good thing the last couple of years is we've gotten better at doing that. It's become much more normal. I do find a lot of farm and ranch folks would like to meet in person. And so sometimes they might make a trip over to Salem. We have a Portland office too, which I don't love going to, just so you guys know, but I will go there if you want to meet there. It might be worth, a trip to meet in person and then do everything else by Zoom, for example.
Perfect. Another question in the chat. What is last person standing with a following comment of connecting multiple business entities?
So, I was here for that conversation, and my partner, Joe Hobson, is the one who's fond of saying that we set LLCs up so that they fall apart, which is counterintuitive because you think you set this LLC up so you can transfer it to the next generation, for example. But really that LLC will say in it, like, okay, you 4 kids are all members of this, let's say, but if one wants out, then everybody else can buy them out. So eventually what you end up with is just another single person owning that oftentimes. So there's provisions in the LLC operating agreement that say, this is the rights to buy out the others, and it's going to be at this amount of money. It might be discounted for minority interests and things like that, because the goal is to keep that piece of land in the family. And in order to do so, you can't just say, well, you guys, if you want out, you can go sell to Walmart or something. You want to keep it in the family. And so you're going to be able to get out, but it'll be at a discounted rate. And eventually be either last person standing will own it all. That doesn't always happen. Sometimes the LLCs will continue for multiple generations, and it can work if you have a good agreement in place on how it's being managed.
All right, thank you. Are there any other questions for Maria? And while you guys are thinking about that, I will send out the recordings. I'll probably wait till after tomorrow's webinar, so I'll send them all at once. Anybody who was registered will receive those. And then I'll send Maria's contact information. I'll send all of the contact information for the presenters that we have. So if you have follow-up questions, I can definitely get you in touch with whoever you need. Is there any final questions for Maria before we jump on into Mark's presentation? With an interest in gifting, is there another way to get the value of the estate without doing an appraisal?
So an appraisal is typically required if you're filing a gift tax return, which is for gifts that are over the $17,000. Some people choose not to do an appraisal, and they will have their accountant say what they think the fair market value is, and then just wait and see if the IRS comes back and requires an appraisal. The nice thing about doing an appraisal at times, though, is it does establish whatever that value is, no matter what. So if you don't have that, you can't really prove it in the future.
Great. Okay, well, we are going to walk right into Mark's presentation. Mark, if you wouldn't mind introducing yourself. I know you didn't do that. I didn't give you an opportunity to do that in the beginning. So if you wouldn't mind introducing yourself, and then we will work through your presentation and then ask questions at the end of yours. So take it away.
Sounds good. My name is Mark Hudson. I am the Rangeland Program Director for Oregon Agricultural Trust, the host here today. I am not an attorney or accountant. I think I'm probably the only one on the speaker series who is not, but I am a guy who's done a lot of conservation easements, well over 100 now with working farms, ranches, or forestry tracts. Today's coverage, I'm just really going to try to cover the issue of conservation easements and how it might fit into your business or estate planning or tax planning to help you kind of achieve your goals. But before I get started, if people can do me one favor, if they can drop in the chat, I mean, a lot of people probably have heard about conservation easements. If you have had overwhelming questions, if you've heard horror stories, if you've just heard things concerning about them, feel free to go ahead and drop them in the chat as I speak. As I go along, if I can address them, I'll try to address them. If not, I'll pick them up at the end. So with that, gonna get forward just goals today. Maria and the speakers yesterday talked a lot about ways of doing your business structuring, tax planning, all these other kinds of things to help with your business and your states. I'm just going to be doing a very refined element of that, but also kind of get into those other reasons why you do estate work, right? Is protecting your legacy, and particularly how you can protect your legacy around land and how it's used going forward as well. I'm probably going to skip the third part of our introduction. It's pretty redundant with the stuff that Maria said. So we're going to first get into just an introduction to first the Oregon Agricultural Trust. And for those of you on yesterday, you heard a little bit, but just to summarize, we are a charitable nonprofit corporation. We're not a governmental entity. We're not a for-profit entity. We exist on private donations and grant funding, and we are statewide. And statewide, we are worried about the loss of agricultural land, both to those traditional ways we lose land development, those kinds of things, but also we really kind of focus, and hence why we're doing the speaker series today, on farm and ranch succession, which is the #1 reason for agricultural land loss in Oregon and really most of the country. I mostly deal with ranchers. I have a specific focus on Southeast Oregon, though I work anywhere in the state that ranchers want to work with us. Southeast Oregon's not too untypical to the issues the ranchers are facing generally, which is, a lot of people right there at retirement age. And it's not the most profitable thing one can do. Most ranchers I work with do it for the lifestyle of ranching, but the reality is the average kind of financial return is about 3%. If people want to do other things with their life, most other businesses have kind of a higher return rate. It's really kind of about kind of legacy of working land and producing food and doing something that you love, I find, with most people, and that's something we care about too. There are other issues obviously out there in the world of ranching, but while we do conservation easements, we're also working with different groups across Southeast Oregon to work on drought mitigation, wildfire mitigation, invasive grasses, juniper, so on and so forth. So what is a conservation easement? So the first thing to understand about a conservation easement is a voluntary agreement. Unless you have significantly violated some kind of law, there is no way to compel anybody to do a conservation easement. And the goal of conservation easements is to maintain the land in an open condition in perpetuity. And what that means is open condition means really any kind of undeveloped land use, and that can be a broad spectrum of things. But generally speaking, it means agricultural or habitat or some other kind of mostly undeveloped space. We mean land use, not no development. It means that it has to be a land use, which in that context works with that open definition. So that means you can have barns, you can have a farmhouse, you can have all these things which are necessary for that agricultural land use. Landowners do them ultimately because they receive cash and tax benefits in exchange for doing the conservation easement, and I will discuss those a little bit later. And what we deal with specifically is kind of a subset of conservation easements, which are working lands conservation easements, i.e. targeted at land which exists to and will continue to exist to produce food or fiber or those other things, i.e. it works for its existence rather than, a habitat-based conservation easement, which might protect a property to exist solely for habitat. So those are kind of when I say conservation easement today, for the most part, unless I indicate otherwise, we're going to be talking about working lands conservation easements for the purpose of protecting agriculture. And to talk a little bit more about kind of the myths and other things that people have heard or have asked me about in my time here. Conservation easements do not take ownership of the land. The person who does the conservation easement and the successive generations of landowners still own that land. The easement is, yes, it's a separate interest, which is just like if you take a right-of-way interest or a utility easement. Those are subdivisions of some of the ownership rights, but there is no ownership that is created in the easement. They are negotiated. So each and every single one of, I think, about 130 conservation easements I've done now have been unique. So they've been negotiated between both the goals of the group that I've been representing, the Oregon Agricultural Trust, the goals of the landowner, and generally speaking, practical things which are necessary for the maintenance of that piece of property. And so, for example, if you have a piece of agricultural land that's only really valuable because it has water rights associated with it, one of the negotiated aspects of the easement might be, hey, you can't subdivide the water rights, or things of that nature. So it's really contextual based on the property. Each one's unique. They do not restrict all uses. Like I said, not only do they maintain the property for agriculture, but oftentimes we hear from ranchers, it would be nice to be able to build another house and my kids can come back when they're done with college. And that's understandable. That's a necessary thing so far as we see it in continuing a farm. So there is flexibility for certain kinds of buildings so long as the primary use of the land is still agriculture. They do not grant any public access. They can, but that's not automatic. And actually, it's an extreme minority of cases that there's any kind of public access granted. And again, that's with the landowner's permission going into the easement. They do not need to cover all of your property. So we don't have to go in and do the whole ranch. Sometimes it only makes sense maybe for your financial goals to sell a conservation easement on a portion of it. Or that may be the part that's particularly threatened by development or so on and so forth. Kind of, again, those are unique to the landowner and unique to the land. So we kind of make those decisions in conversation with each property owner. They are not quick cash. They can be relatively quick tax deductions if that's the way that people want to go. But the cash aspect is not usually quick. We do have to apply for state and federal grants, usually to pay for these conservation easements, and anybody who's dealt with them knows they're not quick. They do not replace land use. Land use laws exist to protect the landscape as a whole and try to protect it for conversion to harmful uses. Conservation easements are focused on individual property. So they really should exist in tangent together. And they are permanent. They do a thing that's known as run with the land in the legal context, which means that even if you sell the piece of property that has a conservation easement on it, that conservation easement is maintained on that property in perpetuity. And it says except here because they are permanent and inviolable except in cases of condemnation. It is actually possible for a condemning entity to take a conservation easement. However, usually a conservation easement being on a piece of a property creates a much better negotiating position when you're talking to condemning entities, because these conservation easements exist for a public benefit, as does condemnation. So you get to argue against two sets of public benefit rather than public benefit versus private benefit. I'm not an expert on condemnation law and how that works, but I have successfully negotiated from a better position when easements have been condemned. Tell you a little bit about land trust generally. There is a number of groups out there who fall into the category of a land trust, and what we all share is interest in holding conservation easements. Generally speaking, we are the fundraisers for those easements when they are purchased. So we go out there and either raise private dollars or write grants or do what we need to do to come up with the cash necessary to do the deal. And we are the holder and enforcer of the easement. So if we have a working land easement on a farm and we come out one year and the whole thing has been turned into a subdivision, we are the entity that has to go out there and hire the attorneys and go after them for that violation or that breach of that conservation easement. We do other things as well. Like I said, I'm working in Southeast Oregon on wildfire mitigation and invasive species, those kinds of things. We all kind of are rooted in land is what we have in common, and so tend to have technical expertise that has to deal with the protection and management of those lands. So to the extent that we can be helpful bringing more capacity, resources, other kind of agricultural land resource management, that's something that we would do. What we are not, as we are not trust as in a will-written trust, we are, like I said, a 501c3, not too different from the Out Club or any of these other kinds of nonprofits that you know in a community. Very different from what Maria was talking about in terms of trust entities. We are not banks either. That is sometimes a point of confusion. What all these entities share in common is that there's some kind of trust element. They hold something in trust. In our case, we hold interests of land in the public trust, hence the name, land trust, but different than a bank. And again, we are not governmental entities. Some governmental entities can and do hold Easements, that's a whole nother conversation for another time. They are not always terrible, but they are usually not so focused on easements, which are also aligned with people's succession goals and those kinds of things. So if you're looking for an easement that aligns with that, and you want help from the easement holder, governmental entities can sometimes be hard to work with. Land trusts tend to be a little bit better at that. And to really kind of narrow into, working lands easements, we only hold permanent working lands easements. We are agriculturally neutral. So we'll work with any kind of agricultural production under any kind of form. So you don't have to be organic, you don't have to be regenerative, though obviously that's the way that CNB is going. But we are really just there to protect agriculture. We are also not the Oregon Agricultural Heritage Program, which funds easements, but is a program of the state of Oregon. We may apply for those fundings, but we have no formal relationship. So that being said, why do people do working lands conservation easements? And there's a variety of different reasons out there. Honestly, I've done them for probably a couple dozen justifications, but the vast majority of them of purpose has fallen into one of four categories. They're either doing it for a legacy purpose, they're wanting to protect the farm and ranch that they've put a lot of sweat equity in, and that sweat equity might span generations. And the idea that all that work that's gone into making that working farm or ranch operation continual might be plowed in for a subdivision, or just, frankly, let to rot, which happens sometimes with a lot of farms and ranches out there. We'll get in, but it can be both a useful tool for succession purposes, both lineally within your family, but also as a way of potentially making land more accessible for non-lineal young farmers or beginning farmer and ranchers. It's a good cash and liquidity tool. It's a good way to raise funds to be able to reinvest in your farm or ranch business, or frankly, whatever you want to put money towards. And it also can be a beneficial tax tool. And so we're going to kind of talk about those four motivations and how to achieve them and what those different benefits look like here as I go through. So I'm going to start with kind of two case studies, again, examples, and these are real farmers and ranchers who have changed the name. So I'm going to first talk about a situation where a farmer, in this case, we call him Hector, was able to use a conservation easement to help to get to some of his goals. And in Hector's case, he had been raising singular row crop types for a long time, actually multi-generation crop type change, but was getting into kind of a situation where urban encroachment hadn't really creeped up on the farm, but he now had access to kind of direct market opportunities in ways he hadn't had before. But to be able to do that, he had to kind of diversify his farm structure pretty significantly to be able to raise different crops. And he did not have the cash to do that at the time. And the only way for him to raise that cash was to actually sell a piece of the farm, which, is a good way to potentially fundraise, but obviously it reduces the amount of productive area of farm that he had. But also when you sell a piece of farm to reinvest in farm equipment and other things like that, it's not necessarily income tax shelterable. And so he was looking at an income tax bill that was going to come from that, and a capital gains tax bill that was going to come from that particular sale of properties. So it turned out to be a better thing for Hector to sell a conservation easement. And actually, when he went and talked to the land trust in his case, they kind of went, hey, Hector, we want to buy this conservation easement, but because of the funding available, we can only pay for half. And normally that sounds like a raw deal, but that actually kind of worked for Hector. In his case, he did what's called a bargain sale, which is when you both sell and donate for income tax benefits a conservation easement. In this case, he did 50-50. His conservation easement was worth about $500,000. He donated $250,000 of that value. He sold $250,000 of that value. He got cash in return. And actually, because he donated the $250,000, he actually created a perfect one-to-one tax shelter. So he didn't have to pay any income tax on that conservation easement sale and was able to put all of that money into the business. And so that worked really well for him. Another situation we'll talk about is Rancher Jane. Rancher Jane, in this situation, had a multi-generation ranch where her kids were just not into it. And she is at retirement age. And so she's to the point where the kids didn't live nearby. And so she wanted to be able to retire and purchase, a home near her kids and grandkids and do something else in the latter part of her life. There was a young family who had been managing the ranch for pretty close to a decade at that point that she really liked and really wanted to sell the ranch to them. But of course, there was a problem. They, in her particular marketplace, there was a lot of speculation in that marketplace. And so the actual value of the real estate value of the ranch was about 40% over what the agricultural production value is. And so when the young couple went to the bank to try to cash flow the mortgage, they could not cash flow it at actual market value. And 40% is a big hit to take for somebody like Jane, who basically all of her retirement assets were tied up. So how did she do that? Well, she turned to the local land trust and she sold a conservation easement. And when you sell a conservation easement, where the purpose of the easement is to reduce the use of the land to only be usable for agriculture, it gets rid of that speculative value. And so the land trust pays Jane for basically that speculative value in the form of the conservation easement. That now then brings the value of the ranch down to the actual market value for agriculture. So the young couple could cash flow the purchase. This gave Jane funding to be able to buy her real estate. And actually, we can talk a little bit later, but she was able to do a 1031 tax swap so that she could take all the money from the easement and from the property sale and put it not just into her house, but also into buying a series of condos for retirement income going into her retirement. So it was a good deal for her. It was a good deal for the young couple. That land is still ranch, and everybody kind of made out well. And so those are just kind of like two type examples of how conservation easements can work, kind of help reach farm and ranching goals. So normally I would break for questions, but we're a little short on time, so I'm just going to keep going. If you guys have questions, drop them in the chat. And I forgot to mention, and very important, we are sending out, or did send out, a copy of our Straight Shooter's Guides for conservation, working lands conservation easements. All this information is replicated in there. So if you guys want to go back and check anything at any time, there are worksheets and other things that you can do to try to figure out if an easement is a good tool for you. So go ahead and check the worksheet that references the things I'm about to tell you. But to talk about what are the very specific easement benefits, get into the specifics of the details, we're going to talk about how you can sell them for cash. And to give you an example, in Southeast Oregon, most of the conservation easements that I am appraising for purchase are about 30 to 40% of the value of the ranch, and does not restrict the use of the ranch for agriculture. So without really any impact on that landowner's ability to farm and ranch, they can get 30 to 40% of the liquidity back out of the property. If you donate the conservation easement or a portion of that, that donated value can be applied for farmers and ranchers against 100% of your income up to the value of the gift. So, if you gifted $500,000, up to $500,000, and up to 16 years. So you can actually use it over a course of multiple years if you can't use it in the first year. And we'll talk about a little bit more about how that can be used structurally in ways that benefit you the best. And like I said, you don't have to just donate it or just sell it. You can do a mixture of the two. But you can also take the proceeds from a conservation easement and reinvest them into other real estate to help grow your business as well. So it's a good way of fundraising to do a down payment or potentially even buy out entirely with cash from conservation easement sales, more land. And there are also some estate tax benefits I'm going to talk about real quickly here towards the end. So those are the individual benefits to you, to the community at large. We're going to talk, but it can be a good tool to achieve affordability for future farmers and ranchers, and obviously helps keep some actual land on the landscape for that use, because if it's all being put to other uses, obviously that next generation doesn't get a chance to get in there and be farmers and ranchers. But there can be some benefits, wildlife habitat. We all know ranches provide good wildlife habitat, but there can also be legal benefits. So, for example, it's entirely possible any number of you have sage grouse on your property. or in a sage-grouse core area. And if that's the case, you are looking down the pipe in the future, the potential that if sage-grouse are listed, there might be federal restrictions that are applied to management of your land. The way to get out ahead of that is you do this agreement with the U.S. Fish and Wildlife Service called a CCAA, which is Candidate Cooperative Agreement with Assurances, which means that if you agree to take certain actions now, they will not regulate you down the road. And one of those certain actions you can do is sell a conservation easement. So with sage-grouse in particular, I try to point out to people, whereas every other action you do will potentially cost you money in terms of land management activities, you can sell a conservation easement and get those same protections. And so that's something else to consider. I'm not going to talk about carbon marketing, but obviously Country Natural Beef has made a big investment on sustainability marketing with regenerative agriculture. And it can be part of that story too, in that, you know, a lot of people like to know that the farm and ranch that they're buying from that is doing right by the environment, the way that they manage things is also permanently preserved. And so it can be part of that good feel good story for potential marketing purposes. So before I get into the specifics of those benefits, I'm going to do a quick review of process. The first thing, if you're interested in conservation easement, is find the person who's going to be the easement holder. Obviously, you can come talk to us. We're interested in doing working lands easements, but there are other land trusts out there, and I would be wrong to not tell you about them. If you are interested in figuring out who those other land trusts are, you can look at the Coalition of Oregon Land Trusts website, and they keep a list of all the land trusts, where they work and what kind of land they want to work on. And there are other land trusts in the state who will do working land easements. But also, if you want to learn more about land trusts in general, good practices, all that kind of stuff, the Land Trust Alliance is the national organization for land trusts who keeps resources associated with all of that. If you're serious about doing a conservation easement, after you talk to the easement holder, you really should start building your team. Minimally, that's going to mean an attorney and an accountant. In terms of somebody who's qualified to actually review the document, this is not just a real estate transaction, but kind of a unique one. So you want somebody who's competent, at least understanding kind of higher order real estate, if not, you know, conservation easements specifically. And obviously there are tax and financial implications. So talk to your accountant. To do these deals, eventually you'll need an appraisal or appraiser, a title company. You might need a surveyor. You might need other resources to look at the property. Talk to the land trust about that. Usually they're actually the entity who hires those contractors and figures that part out for you. But every deal is different. So just know that they're going to be, all the normal real estate contractors are going to be part of the package. So after that, you kind of build your team. What you want to do next is talk to the land trust about the terms and transaction details. So you want to figure out what's going to go in that conservation easement document. What rules and restrictions are you going to abide with? Yes, this is going to have to stay in agriculture. Are you going to be allowed to build 2 houses in the future, or 3? Or are you going to potentially, you know, because there might be a habitat funder who's funding this easement for you, you know, are you going to do some riparian enclosures? Every easement's different. The different funders have their different expectations. Work with the land trust to figure that out. And then obviously all the real estate transaction details. When is this going to go under purchase agreement? For how long? Under what purchase agreement rules are we going to come up with? Once you get all that nailed down, the land trust has to go find the money, which is actually the long and hard part. You would think that all this daunting stuff working with the landowner is pretty hard, but you know, most ranchers I've dealt with are easygoing. Kind of once they get comfortable with something, know what they want, and I think we're pretty straightforward, as are most other easement holding groups. But the federal and state government, never that easy. So the land trust takes on the burden of working with those, but there are forms you'll have to sign and other things. So just help them out as they go through the funding process. And then as the funding process gets assured, they will then execute on all that real estate due diligence to make sure that it's a quality real estate transaction, in particular, because these are perpetual agreements. The land trust and the funders are probably going to give things really a fine-tooth comb to make sure there's no problems in the future. And just to know, these things are not cheap. Most of the time, the land trust will try its best to find a way to discuss how to offset the costs with grant funding or other things first. But, you know, they may ask you for help and, you know, be real about all these real estate due diligence costs, which kind of are usually upfront costs that you have to pay before you get paid by the federal government, the state government, who's paying them when, are you sharing that risk, so on and so forth. Just be very forthright and honest in making sure all of that is taken care of before you get too far down the road conversation. Conservation easements. How do we determine what they're worth? It's actually pretty straightforward. An appraiser goes ahead and values it. And the way they do it is they do what's known as a before and after analysis. And so just like I talked about with that Rancher James scenario, if the value of the properties in the beginning is $1 million, and that's the value of it as is with no restrictions on it, and with all that speculative value, the potential to maybe subdivide it, build extra homes, all these things which are unnecessary for a ranch, that is the as-is value, the before value. Then when you look at the restrictions that might remove the unnecessary housing rights or remove the ability to convert it to non-agricultural uses or other things like that down the road, they'll take a look at that. And so if that value after all those restrictions is known as the before after value, and so before and after assessment, the difference between those two is what the conservation easement is. So if it's worth $1 million with no restriction, $700,000 with the restriction, what the land trust will seek to pay you or give you benefits for tax benefits is just $300,000. And obviously the numbers are very specific to each property and the restrictions that are going. Talk about how the income tax deductions work. The income tax for conservation easements is the income tax deduction for conservation easements is actually the most beneficial tax deduction in the entirety of the tax code, at least for farmers and ranchers. And so it's 100% income tax deduction. That means if you make $100,000 and you gift $100,000, that you can entirely ablate that $100,000 of income assessment for your tax purposes. And you can use it over a period of years. We call it 15 plus 1. And it's 16 years total. You have to use some element of the tax deduction in the first year to let the IRS know that you did the income tax deduction. It can be $1. You can sit on it and wait for a high income year for the remainder of the 15 years if you want to. But you do have to use a little bit in the first year. Or until you reach the value of the gift. So it's not a perpetually renewing tax deduction that you get to take every year for 16 years. You get to do it until you've used all the tax deduction that you gifted. So again, if you gifted $500,000 and you're deducting $100,000 of your income per year, then you can only use that gift for that tax deduction for 5 years. And so it's 16 years for the value of the gift, whichever you reach first. Now, this is a very complicated chart that I'm not going to spend too much time on, but one thing I would say is when you talk to your tax accountant, income tax deductions deduct your income, but the taxes that you pay, right, is based on which tax bracket you are in that year. So if you make a lot of money in one year, you pay percentage-wise of that income more in taxes. If you make not very much money in one year, you make percentage-wise less in tax payment. And so sometimes it is useful if you know a big income tax hit. Maybe you have retirement funds that you're going to have to move from one place to the other, and they're going to be susceptible or liable to income taxes. Maybe you're going to sell a piece of property down the road, even if it's to the kids or anything else. You may be hit with income taxes of a much higher degree in those years. And it may be worthwhile to talk to your accountant about banking some of that tax deduction to be used in those years going forward. Not every piece of property in Oregon can do a conservation easement. They, generally speaking, have to fall in one of 5 qualifying categories. And the first is obviously, it's got to be working land agriculture, and it's got to be land appropriate for agriculture. And that definitionally means different things in different places. But what it really means is that it's got to be a scope, size, scale, and have the resources to do practical agriculture over the long term. So, for example, if you have 20 acres in Clackamas County outside of Portland, that might actually be sufficient enough to qualify for a conservation easement. But 20 acres outside of Burns, Oregon, and Harney County probably does not, just because of the difference in the resources in both cases. So it is a little bit subjective, but one of the things that the land trust does with you first right off the bat is determine whether you qualify. There are other purposes you might qualify, though, that may be interesting to you. There's scenic purpose. Those properties in Mount Hood and Parkdale qualify because they're part of the National Scenic Recreational Corridor along the Columbia Gorge. One that's very common with ranchers, right, is they provide a habitat for these weird little birds. And in doing so, because that is a at-risk species, or if not an at-risk species, listed species also qualify. You can qualify under that purpose. We also do historic structures. In this case, this is the Wooden Shoe Tulip Farm, which is a National Historic Structure. So it automatically qualify for that. And the other purpose is if you provide outdoor education or recreational opportunity for the general public. So if, for example, you are running a farm or ranch school on your farm or ranch and you want to see that preserved, that can be a qualifying purpose. But understand that if you qualify under that purpose, the easement has to preserve it for that purpose. So if you're qualifying for a working farm and ranch, you have to agree that the easement will preserve that property as a working farm and ranch. As scenic property, you may have to make some agreements to ensure that there's sage-grouse habitat on the property going forward, so on, so forth. That is one thing to keep in mind. And again, I'm not going to break because I got 4 minutes, so I'm going to hit everything real quick. Maria and the speakers yesterday talked about quite a few things, people that you should include, quite a few considerations that you should include when doing a conservation easement. When doing your general estate and succession planning, all those things are true also for conservation easement, particularly if the kids are going to inherit the farm and you want to do an easement, include the kids on the conversation, please. Just so that, you don't die one day or something else happen and they find out that there's a significant restriction. And one example is we had a kid who wanted to do a row crop farming. Guy sold a habitat easement that allowed it to be ranched, but couldn't be converted out of managed grassland. And that really kind of screwed with that kid's goals to be able to do, in that case, potato farming going forward on that piece of property. So include all the kids, include all their concerns. Again, how does this fit in your retirement planning? And who do you want to take over the property? That person being needed to kind of, if you know who they are, needed to assess that conservation easement with you. If you don't know who they are, what kind of qualities of person do you want them to have? And in their land management, and keep that in mind when working on the easement. And another thing is just how important is it that the farm business stays in operation as you go. And I use my 1 through 10 scale, which is, if 1 is I don't care at all, and 10 is it is absolutely the most important thing to me that this farm or ranch stay a farm or ranch, then kind of pick where you are on the spectrum. As I put it, if you're 1 to 3, it's probably not that important. You're in kind of I don't really care if it's preserved or not. If you're like 4 to 6, I put you in the nice to have, not need to have category. Go talk to a local land trust and see if after those conversations, it sounds like something more that you want to do. But if you're in that 7 to 10 range, like, hey, this is really important to me, definitely go talk to the land trust. It sounds like this might be the tool for you. And finally, always, what makes your farm or ranch special? What makes it so that it can operate? You know that better than I do. And so make sure that you have that in mind, that you voice it to the easement holder when you're working on that. And you should make sure that that resource, the ability to use that property in that way, is preserved as part of the easement. Because otherwise, it may not be something that is included in the management of the property. As always, remember these very basic considerations when you're doing this and when you're setting money aside or when you're trying to do your tax planning, that you're going to have to plan for retirement, end of life costs, so on and so forth. And then finally, this can be a tool to benefit your estate taxes. Oregon estate taxes, Maria talked through what they are. Know that, again, if you sell the conservation easement before you die, the value of that land has now been depreciated. And so as part of that depreciation, you might lower your tax bill, or you might even get below the $1 million cap, depending on your kind of financial circumstances, what else you have going on. But if you do a conservation easement, one thing to assess is how it might affect the natural resource tax credit. Talk to somebody like Maria about that. It can be done in a way that everything's copacetic, but it can also make things more difficult. And then finally, the big potential benefit is for your federal estate tax. So right now it's pretty high, but as Maria indicated, the bar might reduce again here soon to about that $5 million range in total assets for you to be hit by an estate tax of at least 40%. If you do a conservation easement, there is a specific estate tax benefit that says that the property that you do a conservation easement on, you can further devalue it just for estate tax assessment purposes, not permanently. You can further lower the assessment of that property by 40% or another $500,000, eventually, lowering your estate tax payment significantly or getting below whatever the federal estate tax cap is at that time. So it's another thing to keep in mind. So lastly, know that once you do a conservation easement, you now have this perpetual relationship with the land trust. They do come out annually and monitor a conservation easement. It's usually not too intrusive. It's just really to check if the basics of the rules for the easement are being followed. But at OAT, we try to have a positive relationship. Like I said, we work on other things that improve agricultural lands. And so, for example, if there are irrigation efficiencies you want to work on, juniper cutting, those kinds of things in the ranching world, talk to the land trust. We may have resources to help you get to those other goals. Because again, we want to make sure that you have resilient and long-term sustainable agricultural land. And so we really kind of feel like we want to stand side by side with you in helping achieve those goals. Remember to let us know if you sell or transfer the property. Mostly we just don't like finding out there's a new landowner when we go to doing the monitoring, mostly because I have gotten a call before from people who said, hey, I just bought this piece of land and I just discovered that there's this conservation easement thing on it. It sounds like I can't build all the houses I was wanting to build. Let them know, just so those kinds of potential disasters can be headed off early. And again, the land trust doesn't enforce the easement and rules. So that being said, I think, I'm 2 minutes over. I apologize for that.
Thanks, Mark. One question for you. If a landowner has already exercised all of their development rights, for example, they have the maximum number of residences on their property, what other things can provide value to make it worth a land trust pursuing a purchased easement on their property?
So yes, I mean, obviously, if you've used all the housing rights, it may reduce the value of the conservation easement, but there are other rights that are pretty typically addressed in it, such as the right to mine, right, is usually eliminated by the conservation easement. And really any kind of land use that just cannot copacetically coexist with agriculture. But subdivisions are another one. So it's pretty common that subdivisions are limited or eliminated for farm or ranch properties, depending on the size and the scale and what everybody's trying to achieve. But other things, for example, if you're within the Deschutes River Basin, your water rights might have a ton of value. And if you've agreed to not subdivide or separate your water rights from the property, that might be, anywhere upwards of 50% of the property value right there, just based off of one water rights sale I saw recently in the Upper Deschutes. So there can be a lot of other things that are in the conservation easement that protect it for agricultural purpose that can have a lot of value in return on your property.
Great, thank you. Are there any other questions as we wrap up? 4 minutes over. No worries if you don't have them now. If you want to reach out to Mark later, his contact information is on the bottom of the screen there, and I will be sending out all of these recordings with contact information to everybody that was registered. So feel free to reach out with questions afterwards. A final call for any other questions before we sign off today. Awesome, thank you. I want to thank Maria and Mark both for today. Really great information, a very packed 2 hours. So I appreciate everybody in attendance, and hopefully we will see you tomorrow.
Thanks, everyone.